Hey guys, happy Tuesday. Welcome back to my channel. Hi, Bon Bon Bon. Hi, China Girl. Hey, Boo. Hi, everybody. Okay, so happy lunch. Okay, happy lunchtime. So I am gonna come back and go live at 2 o'clock. But I wanted to do a couple of quick updates because you guys were messaging me yesterday and you're like, I know you're watching The Verdict. Yes, I saw The Verdict. I wasn't surprised though. Like a 3-time convicted murderer not being convicted of murder. The only thing that I thought, okay, and we're talking about Lori Vallow for a second. The only thing I was concerned about was it was a very circumstantial case, and we didn't know if the people were going to know what they needed to do, right? Because there was a lot of information cut out. So there were people on pins and needles yesterday wanting to be sure that justice was served for Charles, right? So one of the jurors said it was the timeline, another juror said it was the text messages, another juror said it was the lies for her. So it was interesting getting to hear from the jurors and everything if you watched it yesterday. But let's girl, I was like, baby, I think she already knew what was gonna happen. I mean, you know what I'm saying? Let's just listen real quick. It's not long. But Lori Vallow, if you didn't know, Lori got her guilty. She's getting ready to go on trial again for another person they tried, but were not successful in killing, Brandon Boudreaux, her niece's husband at the time. Um, Baby, a mess. Okay. So the conversation will still continue around Lori Vallow. Don't make no mistake. If you were enjoying Lori talk, baby, Lori talk's not over because Lori has a whole nother case starting next month again. So she's racking them up. Um and the jurors were quite compassionate. They were, they kind of felt sad. They felt sad for Charles and they felt sad for her. Can you believe it? Of now 4-time convicted murderer. They felt sorry for her. Isn't that interesting? Okay, she's a multi-state murderous felon. Okay, period. All right, let's hear what's going on here. Hold on. It is kind of underwhelming. We're not gonna see like the crash and burn, crash out of guilty and
I'll ask the clerk to
oh
read
my
and record the verdict.
god. We're not gonna she's gonna be very mellow and all we're seeing is the back of her head.
In the Superior Court of the State of Arizona in and for the County of Maricopa, State of Arizona versus Lori Daybell, CR 2021-001704-001, verdict count 1. We, the jury, duly impaneled and sworn in the above entitled action, upon our oaths, do find the defendant, Lori Daybell, as to the crime of count 1, conspiracy to commit first-degree murder occurring on or about July 11, 2019, guilty. Signed, foreperson. Is this your true verdict? So say you one and all.
Yes.
On the court's own motion, I'll go ahead and ask the clerk to poll the jury.
Juror number 1, is this your true verdict?
You can tell she's pissed. Those shoulders are tight.
Yes.
Juror number 2, is this your true verdict?
Yes.
Juror number 6, is this your true verdict?
Yes.
Juror number 7, is this your true verdict?
Yes.
Juror number 8, is this your true verdict?
Yes.
Juror number 9, is this your true verdict?
Yes.
Juror number 10, is this your true verdict?
Yes.
Juror number 11, is this your true verdict?
Yes.
Juror number 12, is this your true verdict?
Yes.
Juror number 13, is this your true verdict?
Yes.
Juror number 15, is this your true verdict?
Yes.
Juror number 16, is this your true verdict?
Yes.
Thank you.
All right, I'm going to ask the jury to retire to the jury room for just about 2 minutes. I need to discuss something with the parties before we determine whether you're done or not. So the admonition still applies. Please go to the jury room for a few minutes.
All right, to the jury.
Okay, so the next thing that was going to happen is kind of different for Arizona. There's something called aggravators, and it was almost like to me, it was giving like, are you pleading guilty to the aggravators? I mean, she's been found guilty by the jury. And maybe at this point, I guess we need to do some research,
All right,
and I need
proceeded.
to
The
read
jury is-
to understand a little bit more about it. And I'll be honest, I did not read the Arizona kind of aggravators to adequately understand to explain it to you, but that's the phase that they're getting ready to get into. So just listen, and if you guys are interested in knowing a little bit more, we'll figure it out. Sis knows, sis knows how to Google and read, so we could figure it out. But this was interesting when I heard this, but I didn't have enough time to research like the meaning of this part of the process.
Is no longer present. I'll ask the defendant, you indicated earlier perhaps a willingness to stipulate to aggravating factors. Is that something you want to do, or do we want to go through this aggravation phase?
I'm willing to stipulate to it, Your Honor. All that it is the dangerous phase. Is that correct? There's only one there's only one sentence.
Well, the jury would need to find, first of all, whether or not this is a dangerous offense first. Secondly, whether the offense caused physical, emotional, or financial harm to the victim, or if the victim died as a result of the conduct of the defendant caused emotional or financial harm to the victim's immediate family. And then thirdly, the offense involved the presence of an accomplice. If you're willing to stipulate to all three of those, we can do that. If not, we'll bring the jury back in.
I will stipulate to it, Your Honor.
And this could be potentially these aggravators could be something that could determine whether a death sentence is, she gets a death sentence or not. If I'm reading this correctly, this main section is broken upon 10 subsections, one for each aggravating factors. Each belongs with an introduction of the law concerning the aggravating circumstances, followed by the case annotations in chronological order. The case citations are divided into upheld and reversed sections, and further divided into the law regarding the circumstance has substantially changed at some point. For example, old law, new law, general principles. So it kind of explains to you some of these aggravating circumstances. And she's going to cop to a couple of them. But based on that, what does that mean in her sentencing? So these are part of like the capital sentencing guidelines. The guides are created for the capital staff attorneys of the Arizona Death Penalty Judicial Assistance Program to assist Arizona Superior Court judges. The guide is updated throughout the year with significant legislature changes and made relevant sections of the Arizona revised statutes. New capital cases opinions are released. Okay, so they're basically saying that they keep this very up to date. Let's see, capital cases marked as blank denotes cases with so additional aggravating circumstances. So she's copping to these aggravating circumstances. I don't know if they're going to give her a death penalty. Like, I need to read a little bit more to understand, but what she's getting ready to cop to is going to have a determination on when he sentences her.
All right. You understand that if you stipulate to this instead of a jury finding, well, let me back up. You understand the jury would have to find these aggravating factors beyond a reasonable doubt?
Yes.
All right. And do you understand that if you stipulate to these factors instead of a jury doing it, I could also find additional aggravating factors at sentencing?
Sure.
Has anyone forced you or threatened you in any way to get you to stipulate to these factors?
No.
Has anyone promised you anything to get you to stipulate to these factors?
No.
Have you had any drugs, alcohol, or medication in the last 24 hours?
No.
Do you agree that pursuant to the jury's verdict?
Okay. This is what AI is telling me. In Arizona, stipulation to aggravating factors in a criminal case means the defendant agrees with the prosecution's assertion that certain circumstances surrounding the crime make it more serious and warrant a harsher sentence. These factors outlined in ARS, so Arizona statutes 13701D, can include things like use of a deadly weapon, serious harm to a victim, a crime being committed for financial gain. By stipulating to these factors, a defendant avoids having the state prove them in trial. So had she not stipulated to them, they probably would have had to bring the jury back and listen to another set of circumstances, and she's probably done at this point. She's like, you could tell she's giving, I'm done. The defendant avoids having the state prove them at trial, potentially simplifying the sentencing process. Here's more detail looking at what happens when a defendant stipulates to. So when you stipulate to, it could be reduced burden of the prosecution. When the defendant stipulates, the prosecution doesn't need to present the evidence to argue for the existence of aggravating factors. She basically copped to it. Potential for a harsher sentence. If you drag this out, it's not going to be cute. Okay. It's not going to be cute stipulation. So if you stipulate, they're not going to drag you as harsh. Okay. Impact on plea bargaining. Stipulating to aggravating factors can sometimes be part of a plea bargain where the defendant argues to plead guilty in exchange. Well, she didn't plead guilty. She was found guilty, but she did cop to the stipulations. Before agreeing to stipulate, the defendant must understand the consequences of doing so, including the potential of a harsher sentence. We just heard the judge say that. Okay. We know what it means now. We understand what's going on.
Of guilt that this would be a dangerous offense because a deadly weapon or dangerous instrument was used.
I'm stipulating to it.
You agree that that's what that this is a
It's like, Lori, just answer yes.
dangerous
Stop.
offense.
Stop it.
Correct.
And you're further stipulating that as a result of your conduct, at least the victim or the victim's family suffered emotional or financial harm.
Absolutely.
And you're also further agreeing that the offense involved the presence of an accomplice.
Yes.
Is the state satisfied with the colloquy?
Yes, Your Honor, it appears it's knowing voluntary.
All right, the court does find that the stipulation to those three factors was knowingly, intelligently, voluntarily made. I will accept the defendant's stipulation. At this time, I'm going to bring in the jury and release them from the admonition. Before we do that, well, as my staff's lining up the jury, do you want to have a sentencing date within approximately 30 days, or do you want to wait until after the next trial to be sentenced on this matter?
What does the court prefer?
It doesn't matter to me. Maybe you want to talk to your attorneys or advisory council about that. We don't have to do it right now. You can do it in a few minutes. Please be seated. The jury is present again. Members of the jury, you are now released from the admonition. This concludes your jury service. I want to thank you for your jury service in this matter and your attention in this matter.
All right, we're going to fast forward through. This happened yesterday, like, I don't know, was it around 4? No, it wasn't 4 our time. It was a little later in the afternoon on the East Coast, but
Wait till after the next trial, Your Honor.
Okay.
she's going to wait till after the next trial.
Whether or not
At the end of the day, I think she's kind of done. I think she's lived out her fantasy of playing lawyer. I don't know if she's going to go pro se, but I did hit the like button. Oh, thank you, boo boo. I appreciate that very much. Thank you, hun. So someone said earlier, why bother to have a trial? Why not? You know what I mean? She doesn't care. She's a narcissist, you know, and you guys know me. I don't throw that word around lightly, but she is. She's a narcissist. Something's wrong with her. She's just got a screw loose, okay? Um why not? Because she can, and this is her way of, this is just her doing her. Lori is about herself. So it doesn't surprise me. I just wonder, based on the stipulations, will that have an effect? Because they can use, I wonder if they can use that information in the next trial about her stipulating and agreeing to the aggravating factors in another trial related, you know, closely related to the next one. Will that be something that they can use against her? So I don't know. But anyway, just to get you guys caught up to date, Lori Vallow has been convicted again. I don't think that was a shocker to anybody, but I think to the people who were on pins and needles and concerned about the case and the amount of evidence, there's just not that many coincidences. Anything could have happened, and possibly with a good lawyer, she may have been able to skirt around some things. But based on the fact that she was representing herself and she wasn't able to catch half of what could have been caught to kind of help her case, sis then got convicted again. Okay. So it's her constitutional right. Okay. So ma'am will be sentenced after the next trial, and we'll be on some Lori Vallow again pretty soon. Let's pivot real quick, guys. Ooh. Oh, hold on a second. Let me pivot real quick. Just a second. So yesterday, Bible Lady asked me what was going on with Stephan Stearns, and I knew he had court this week, but I didn't realize there was a hearing yesterday because his lawyer had put in a motion to suppress some evidence that had been collected from his telephone. So they had a or continue the motion to suppress. So she filed a motion to suppress some evidence, but she also wanted to continue the hearing to suppress the evidence. So basically push out, and that could have delayed the case. And guess what this judge said? Nope. I think I told you guys this yesterday, didn't I? I think I looked it up while we were live, but I didn't have a chance to read all of the information. And girl, baby, the judge said no. The judge was like, no. And you know who's on this case? Mr. J. He's from the 9th Judicial Circuit in Florida. And baby, he said they were like, no, ma'am. So they are having a hearing today. It's set for approximately 3 hours. They have evidence that they will be presenting. I think they might have some witnesses. So it might be pretty interesting. That's why I set us up for 2:00. Okay. So let me show you guys. What's today? Today is the 23rd. Okay. All right. So yesterday, okay, bye Lori. Bye Lori, we'll see you soon, okay? So this happened. So this was the notice of hearing for yesterday, right? This actually got denied, okay? So this can all make sense. So that was the notification for the hearing yesterday that we missed. But we didn't miss it because guess what? It's available. We can watch it real quick. It's only about 12 minutes. This is the notification for the hearing today at 2. And to remind folk that they're starting on time. There's no reason. The judge said we have no reason and no standing to postpone anything at this moment, and we're going to proceed. Okay. With everything as scheduled. His lawyer tried to argue that she has some new evidence, but she can't share it. It's key to the defense. It's confidential. She can't give the information. And he said that there was no compelling reason for him to postpone anything. So it was denied. Okay. That was that. And this was the motion that was filed on the 14th, the motion to continue the suppression hearing. And basically what she's saying here, the defendant Stephen Michael Stearns, or Stephan, excuse me, buying through the undersigned attorney pursuant to the Florida Rule of Criminal Procedure 3.190F, and moves that this court enter an order granting a continuance of the above style cause and grounds in support of the motion of the defense to show the defense's motion to suppress hearing are scheduled on 4/23/25 at 2 p.m. Pretrial conference is to be heard at the same time and scheduled motions to suppress. The defendant has been charged with 60 counts of various allegations involving sexual battery, lewd and lascivious molestation, possession of child pornography. A conviction of any of the above may serve as an aggravator. We're now hearing that for the second time today in the defendant's other open case where the state is seeking a death penalty, as evidenced by the state's notice of intent to seek the death penalty filed in that case. Apparent number 5, the apparent centerpiece of the prosecution stems from the media obtained through the search of the phone attributed to the defendant. On number 6, on August 6, 2025, the defense filed 3 suppression motions challenging the exact evidence. Since the filing that motion, the defense has come into possession of a confidential information that may impact the presentation of the evidence at the hearing. Number 8, the defense will not have time to develop the evidence before currently scheduled for the motion to suppress scheduled hearing on the 23rd. As such, the defense is requesting to continue these hearings to reset for a later date. But you got the trial starting in like 3 weeks or less too. As such, the defense is requesting to continue these hearings to be reset for a later date, that this motion be filed in good faith and not for the purpose of a delay. Ma'am, the state objects to this motion. The state, and then number 11, the state objects to this motion to continue. I guess maybe that means we've contacted the state and the state was like, no, go ahead and file it and we'll let the judge decide. And basically the judge decided yesterday. I'm sorry I didn't share that. Hold on. I thought I was sharing it because it was on my screen, but it was not on yours. Okay, so I've got this. If you are interested in any of this, I will post it on Patreon and post it for you guys. But that's that, right? This hearing went pretty quick, but he's back in court today. And they're basically trying to throw out some evidence that they said was potentially not obtained legally. And where have we heard that before? We heard that in Nesto's case. So this might be here, even though it's a completely different state, it's a completely different set of circumstances, but it also does still include CSAM. It includes similar type of illegal material. I'm gonna say it like that. And yeah, it's including the same type of media, if you will. Even though this person has a case that is just unimaginable, how much media that he has, including the victim and how bad it was. But you know, at the end of the day, it's interesting, and we're going to see what they tried to do to have this thrown out. So anyway, he was in court yesterday. This ran about 12 minutes. So let's listen to the argument. Spoiler alert, it was denied to basically postpone today's hearing. But today's hearing is where they wanted to kind of they wanted to continue that. And if they had continued it, that could have delayed the start of what they say is supposed to be his jury trial starting like less than 2 weeks. So, and she said on the document, we're not trying to delay the trial, but that's what it would do, right? So, okay, let's get into it. Again, this was yesterday, guys.
We're on the record, State of Florida versus Stephen Michael Stearns, 2024 CF 632. Appearances for the record, please.
Danielle Pennell and William J. for the state.
Alicia Smith and Alex Johnson on behalf of Mrs. Stephan Stearns.
Thank you. All right, the court has set this hearing on the defense's motion to continue the suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present argument with respect to your motion?
Yes, Judge, and defense has a case. I provided a copy to the state already.
The one thing I just wish she would use her microphone more.
You want me to give you a moment to read, Judge, or you want me?
Just a moment. These highlight the McKay factors.
Essentially, yes, they are essentially the same for the same
I'm
purpose.
familiar with the McKay factors. Thank you.
And the cases that I provided to the court are Botham v. State, 272 Southern 3rd 876, a 50 CA case from 2019, Turner v. State, 311 Southern 3rd 185, a second DCA case from 2020, McKay versus State, first DCA, 504 Southern 2nd 1280 from 1986, and unpublished opinion, we only have the Westlaw site so far, Surratt versus State, 2025, Westlaw 1119091 from last week, from April of 2025. Trocola versus State, 867 Southern 2nd 129, 50 CA from 2004. And Singer versus State, 286 Southern 3rd 343, a 50 CA from 2019. Essentially, Judge, defense is moving to continue the motion to suppress this step for the afternoon, tomorrow afternoon. And looking at the Bofo case, it essentially says that in moving for a continuance, defense just has to show that we haven't had a reasonable time to investigate or litigate the case. And that is balanced against the judicial economy and judicial efficiency in the court managing their documents, turning to the McKay factors, as well as the factors that are listed in, I believe, Turner, that looks to a defense suffering an injustice by failing to grant the continuance, as well as if the delay was attributable to the defense or if it was unforeseen. Defense would argue that the intention is not to delay the court, isn't to be derelict in our duties. Defense is moving for this continuance based off of, as the court is aware, there is the second case, and preparing for the motion, as well as in preparing the other case for trial. Defense is coming to information that at this time, defense isn't in a position to be able to divulge to the court or in open court.
So your good cause is secret?
Essentially, Judge, well, I can't in good faith at this time, being that it's still being explored. I don't know which way it's going to go, if it's going to be something that's going to pan out in favor of defense or be able to be something to be utilized in this case. As the court is aware, a death notice has been filed in the second case, and while I'm not arguing specifically as to that case, in that death notice, this case is used as one of the aggravating factors. So a conviction on this case would be one of the aggravating factors the state would potentially be seeking in the death notice in terms of a homicide case. Defense would argue that this information has come to light recently, and we're still in the process of working through it and figuring out if it's something that would or wouldn't be available in this case. If the defense were to go forward with the motion to suppress at this point, potentially would be relitigated depending on the court's ruling on that. In terms of just regular pretrial in the case, we would to continue the regular pretrial even aside from the motion to suppress hearing, because we did an evidence viewing, we weren't able to complete the evidence viewing, and the second part of that evidence viewing is scheduled for June 11th with the state in this case. So defense essentially is moving to continue balancing the Beaufort factors as well as the McKay factors, defense believes that this isn't a unreasonable request on the court in filing a motion and getting this set for a hearing and still doing their due diligence in terms of preparing the case otherwise for trial and for the motion to suppress in and of itself.
Right. So the McKay factors, so we're on the same page, deal with a request to continue the trial. The other factors that you mentioned deal with a request to continue either a trial or a substantive hearing for absence of a critical witness. State response?
Yes, Your Honor. The state has not been in receipt of any witness list or any defense discovery in this case. The defendant in this case was arrested on February 29th of 2024. The public defender's office was appointed the next day at initial appearances. The discovery process started after the information was filed on March 11th of 2024. The state responded to the defense's demand for discovery on March 20th, 2024, and discovery has been ongoing. The motions to suppress that are currently set for hearing tomorrow were filed by the defense on February 6th of 2025. There was a motion to close the courtroom.
Hold on a second. I'm going to stop right there. Basically, I mean, damn. She's like, look, it's been 14 months. It's been 14 months. And we set this, you sent your motion to suppress 2 months ago. And you just got some evidence and it's the day before the hearing and you want to postpone the hearing? Baby.
On February 28th
Which is taking place today?
of 2025.
Oh, okay, Bible lady. I see you now, hun. This update is actually just for you, boo, and all of Bougie Gang, of course. But you requested this yesterday, and sis was exhausted. Okay, but I came with this today for you, and we will be live at 2:00 with the actual motion to suppress hearing. This was the hearing to continue the motion to suppress today at 2, which I'm going to say again, spoiler alert, it was denied.
A notice of hearing for the closure of the courtroom was filed February 24th of 2025. Upon the denial of the defense's motion to close the courtroom on March 27th of 2025, the defense filed a notice of hearing for these motions to suppress. So these have been pending hearing since March 27th of 2025. The defense filed the motions to continue. The defense waited approximately almost 2 months, 2.5 months to request hearing time. The hearing has been set. The state filed responses to the defendant's motions to suppress on April 8th of 2025. And then I was contacted by defense. We had a discussion about their request to continue these hearings on April 10th, and a written motion to continue was filed on April 14th of 2025. The written motion filed by defense, the state's position is vague. It is unclear whether this information is necessary for a defense, is necessary for the hearing. The motion simply states that it may affect the presentation of evidence. The state has subpoenaed witnesses. We have a significant amount of hearing time scheduled for tomorrow afternoon. The state's prepared to proceed on the motions and is objecting to the motion to continue the suppression hearings.
Thank you. Any additional argument from the defense?
Yes, Judge, defense would say that this is for the defense, even if the court were to ask ex parte in terms of, to have ex parte hearing in terms of the basis for the motion. I don't believe at this point defense will be able to disclose that information even to the court, even if the ex parte hearing were requested and or granted. It's defense's position that this information is necessary to be explored in terms of, it's necessary to be explored in terms of the presentation of the evidence or presentation of the case, because It's the defense's position that at this time, the information is confidential which is why a witness list hasn't been disclosed. Discovery exhibits haven't been disclosed in regards to it because it's still being looked to and explored. As the state indicated, discovery is ongoing, and as discovery has continued to be ongoing, so has defense's preparation of the case, reviewing of the motions, filing of the motions, preparation of the motion, as well as in preparing this case otherwise for trial alongside the homicide case. So it's defense's position that the granting of the continuance in this case would not be an undue burden on the court. I understand the state having subpoenaed witnesses. The day that I found out about the information was the same day we actually happened to have depositions. So I spoke with the state in person about it, and then sent her an email in regards to her position. And then from there, filed the motion to continue. And then we got hearing times while I was in trial with Your Honor as another case, and I filed a notice of hearing as to that. Defense has been preparing, defense is preparing, and it's defense's position that denial of the motion to continue in this case would be an abuse of discretion, and we'd be asking the court to grant the request to continue.
Thanks. Well, the court's in a difficult position evaluating the McKay factors. In this case, the court's going to find that there has been significant time to prepare for these hearings. This case initiated in February of 2024. Motion was filed almost a year later. The matter was set for a hearing in March. 13 months. I'll note that this is on 24 CF 632. While the two cases are related, this does not deal with the homicide case. The court has an inability to make a determination as to the likelihood of prejudice from the denial. The defense apparently is in possession of some information, the nature of that information, the timing of when it was received, whether the defendant played any role in shortening the preparation time. The availability of that discovery is unknown to the court because the defense is unwilling at this point to share any information with the court, even on an ex parte basis as to this information. Counsel that has been appointed to this case has the requisite skill and experience to try this type of case. Both are either board certified criminal trial experts or in the process of becoming are being certified as a criminal trial expert. The court cannot, from the information presented, make a finding of a good cause. And while the defense argues it will be prejudicial, there's been nothing advanced to the court to support that argument. So the defense's motion to continue the motion to suppress tomorrow, scheduled for 2 p.m., is denied. And I'll ask the state to please have their witnesses present and ready to go.
No problem.
Thank you. Matter set.
The state said no problem. She's like, I'm sorry. Like, his attorney is like, look, she seems pretty together and everything. Miss Ma'am, Stephan's attorney. Let me see what her name is, y'all, with all due respect. Let me, ma'am, her name is that Melissa Vickers? Yes, Melissa Vickers, right? Is that Melissa Vickers, public defender? Oh, Alicia, is it Alicia Smith? It's Melissa, maybe it's Melissa Vickers' office, and Alicia Smith is his actual attorney. Let's see when she put in her appearance. Let's see what she said. Hold on.
Suppression hearing, which is currently set for tomorrow afternoon at 2 p.m. Defense, do you wish to present for the record, please?
Danielle Pennell and William J. for the state.
Alicia Smith and Alice Johnson on behalf of Mrs. Stephan.
Okay, so Alicia Smith, she's so the public defender's name is Melissa Vickers. She is Alicia Smith. Okay. Look, the state basically came, and the state, as you're seeing right there, that's Mr. J. If you remember the Sarah Boone's trial, and how can we forget? I mean, baby, that was epic, right? So Alicia had a lot to say, but kind of didn't say anything. She gave us a lot, but it went over like a little. Can we get 21 thumbs up? Is there any, if there is anyone who has not yet hit the thumbs up for me, go ahead and hit the thumbs up. Okay. We appreciate you tapping in. And thank you, moderators. You guys are awesome. It's too late. And also, what did the judge say? This is not the murder trial. Basically, he didn't say, I'm paraphrasing, okay? This is not the murder case. We're doing the CSAM case. So you working on the murder case is not my problem. Now, I don't even know if it's the same judge. I'm going to be honest. I haven't looked at the murder case in a minute to be able to compare, like, is it the same judges? But apparently she is working on the murder case with him. And at the end of the day, the judge is like, he has these 2 competent attorneys. Everybody's certified or almost certified. Like, this is not for lack of knowledge, experience, training. This is not for lack of time, because ma'am from the state side has already put in the timeline, and the timeline has been more than sufficient. So, and also on top of that, STEPHAN STERNS' attorney has said she can't share what she has because it's confidential. So he's like, I have nothing to go on. I'll see you guys tomorrow at 2:00. And that's basically what that was. So yeah, yesterday Bible Lady asked me about this, and I knew he had court this month, but it slipped by me that this hearing was happening yesterday. And I knew about the one today, and it was on my calendar. So we'll watch that today at 2. But I wanted to get you guys up to date on the shenanigans of yesterday. And yes, his attorney tried it, and she's doing her job. So shouts out to to her for doing her job, because we see that there's people out here who don't appear to have the same luxury. Okay. So Stephan's lawyer seems to be working for him, but apparently the state is keeping up with that timeline, and they are not having it. Hey, Jasmine. Hey, Boo. Hey to everyone here. Okay, let's pivot real quick, and then I'm gonna let y'all go. What time is it? 1:00. So we'll have a little break time before I go live at 2. So I hope you guys will come back and join me. Portia's going crazy because the postman just pulled up. Now, one of you guys sent this story to me, and when I looked, I was like, gosh, this is like been all up in my timeline. This is a mess. Okay. Hold on, let me pull it up. This has been all up. I'm sure this has been in your timeline too. Portia, hush. Let me put you guys on mute for a second. Portia is going bananas. The postman just pulled up. Okay, just a sec. Okay, I had to quiet them down a little bit. Okay, so this is the teacher who was having a sordid affair with a soccer student, she's a special ed teacher. She was in a full-on romantical situation with a damn 15-year-old. And she's a nice looking young woman with a nice looking husband, and seems like things were going well. And sis needed to be silly slapped, because she is over here messing with somebody's son and having far too much going on with a child. And it's absolutely ridiculous, and it's a mess.
Very own WGN News at 9.
Good
15.
evening. I'm Micah Matera.
And I'm Ben Bradley in for Ray Cortopassi. A Downers Grove South High School teacher and soccer coach now facing felony charges. She's accused of having sex with a student, but claims she's being set up.
WGN's Brona Tumulty joins us from Downers Grove with details. Brona.
Let me interrupt for a second. This trick has been texting this dude like he's a grown man. You know what I'm saying? She's 30. She's been texting him like he's a damn 33-year-old with a job, a mortgage, and like holding her up. Like, what you getting ready to do? You know what I mean? She was talking to him like he's a man and he's 15 living over at his mama and them's house.
Good evening. That teacher was released by a judge this morning following arraignment on 2 conditions. She is not allowed on the school grounds and not allowed any contact with anyone under the age of 18. Officials with the district making a brief statement about the matter tonight.
This morning, we learned that a DGS teacher was arrested and detained by law enforcement.
Don Renner, president of the Board of Education of Community High School District 99, speaking this evening in Downers Grove. That teacher he's talking about is 30-year-old Christina Formella, now charged with aggravated criminal sexual abuse and assault. Formella started with Downers Grove South High School in 2020 in the Special Services Department, joining the coaching staff of both the boys and girls soccer teams in August of 2021.
We are heartbroken for the victim and also for the hundreds of students, staff, and family who trusted this teacher and feel betrayed by this terrible situation.
The victim at the centre of this scandal is a current student who came to the police station on Saturday with his mother to file a report. Per court documents, explicit text messages surfaced, which the teenager says were between himself and Formella. He alleges a flirtatious relationship resulted in sex once in December of 2023 in one of the classrooms. He was 15 when that allegedly happened. Formella would have been 28.
Our top focus now is to support the victim and their family.
After taking Formella into custody yesterday, it's understood a lengthy notes entry obtained on her iPhone appears to reference a relationship with the teen, stating amongst other things, "We will never ever be together again. I'm not a second choice. I'm the best thing you'll ever have, even with all of my mistakes." Formella
Can you
adamantly
believe this
denies
trick
having
was?
sex with the victim,
Hold
telling
on a second.
detectives per those
This
court documents that everybody comes after her because she is
girl, she thinks everyone's coming after her because she's pretty. It's another Sonya. Can you believe she was talking to this boy like he's a damn man with making about 6 figures, his own house, and damn, she was talking to him like a man, and he's 15 at the school. On top of that, sis married and has a nice looking husband. And this guy is showing up with her to court every day. Every day that she's been going to court, husband walking into court with her. Absolutely bananas, okay? Absolutely bananas. Everybody comes after her because she is good looking and she's just a good person who cared too much. I just want to know what planet these people come from who excuse their bad behavior, girl, on this type of foolishness and come up with these answers like it's actually real.
stating amongst other things, "We will never ever be together again. I'm not a second choice. I'm the best thing you'll ever have, even with all of my mistakes." Formella adamantly denies having sex with the victim, telling detectives per those court documents that everybody comes after her because she is good looking and she is just a good person who cared too much, whilst reportedly adding she knew her relationship was wrong but was unable to stop it. Now, in question further about the text messages on the victim's phone, Formella alleges in court documents that the student accessed her phone and sent the messages to himself as blackmail. The school reiterating.
He took her. Can you believe how stupid that sounds? He took your phone and sat there and texted himself from your phone, answered, and wrote all that girly, stupid, girly, insecure, narc dialogue. So you think a boy of 15 could get into the head of a insecure narc female and dialogue it just right? And he's blackmailing you? Interesting. Interesting. It'll be interesting to know if when they get the IP addresses and they have the forensic analyst figure out where those text messages were sent. And sis, if it's pinging over to your house, girl, you gonna get caught in more lies. Okay, she didn't think her lie all the way out, because we know that not only can they check the IP address, they can also check where the phone is pinging. So now that she wants to introduce a sophisticated lie and accuse him of text-lying, they're going to pull that data, baby, and you go look stupid.
Tonight, they'll be reaching out to families whose children had direct contact with Formella. She, meanwhile, has been placed on administrative leave with pay and is due back in court on the 14th of April. Well, that's tonight in Downers Grove. Brona Tumulty.
Look at our sis from Ireland. Look, there's no way she can, it's like, ma'am, there's no way, you're busted. Okay. All right. Let's catch this, because this, hopefully I pulled the right one. Hold on a second.
Paul 61, traffic stop.
What did it say? It said gross illicit conduct. Hold on. How embarrassing,
61,
right?
traffic stop.
Do you imagine you're pulling into your driveway?
It's
and
every
like,
parent's absolute worst nightmare.
oh shit.
For one suburban mother, it began on March 15th, 2025. While updating a newly purchased mobile phone, old text messages began to download from iCloud. Within them, the mother made a shocking discovery.
Do you imagine finding out that your son, I don't think this is the one I really wanted. This part should be.
Place Formella on leave and bar her from entering the property. Formella, who denies the allegations, would say in her own defense, "Everyone comes for me. I'm good looking."
Everyone comes for her.
No, I'm not gonna look
Okay.
for her. Hey, how you doing?
Hi.
Officer Guzman with Downers Grove. Do you have your license on you?
Tonight.
Yeah, I'm gonna explain. I'm sure you're confused. I'll explain everything to you. You're Christina?
Yes.
Okay, Christina, do me a favor. Can you step out of the car for me? I know you're confused. I'll explain everything to you. You don't have anything on you? You can just grab whatever you need.
Whatever I need.
Yeah, whatever you need, like your phone, your purse, go ahead and grab it.
Is she going somewhere? Or?
Yeah, we're gonna explain everything to you guys.
Look at her sweatshirt. It says Kill Crew, which I don't know what that means. Maybe it's a band. And then your husband's there.
Go ahead and grab it out. We're not going anywhere right now. Of course, yeah.
Do you have an explanation? Your wife has been up to the shits. That's what the explanation is. Your wife has been messing around with kids at the school.
And what's going on here?
I get it, yeah. You can go grab your things.
Can he come with me?
Yes. You stay there for right now, sir. Just stay there, but yes, you can. But come on back here.
Should I shut the car off?
Oh, yeah. Go ahead. Goes off. Okay. Let's right back over here. So we do have an investigation going on. We have to talk to you about it at the police department, okay? So we're going to explain everything to you there. It's not my investigation. I don't know the full details. We do have to bring you there, though, okay? So I do have to put you in handcuffs and bring you to the police department.
She's looking like
Just
what?
Handcuffs?
Yes, unfortunately, yes.
I'm like willing to go with you.
I get it, yeah. Unfortunately, we have to do it that way. So do me a favor. We just take this off.
Can I ask you
Of course, yeah. It's not, like I said, it's not my investigation. Obviously, we're here for a reason. So go ahead and turn around for me.
How embarrassing.
So right now, you're just being detained, and there is a detective that needs to talk to you at the police department. So we'll let your husband know he can just come to the police department as well if he wants to wait for you there.
I'm like,
I get it. You have a lot of questions.
so scared.
Yeah, everything's
No,
okay.
she
We
didn't
just
have
need to talk to you.
questions. She just said she was
That's all.
scared.
Nothing else on your pocket right now? Anything else?
My phone.
Just your phone?
Here.
Okay. Okay. right, we're gonna sit in the back of this car. On the other side, once you get to the police department, you'll talk to the detective and he'll explain everything to you.
But you can't even give me like an idea
At the moment,
as to what this is about.
Other than that, it's an investigation. That's all I can really tell you right now. I'm sorry. I wish I could tell you more.
Is he coming with me?
We'll let him know right now.
Your wife has been busting it open for a 15-year-old.
We have a female 95 transferring. Sorry, Miles. 505. 505.
Excuse me, is my husband coming with?
Yes, yeah, he's taking his phone number down. We're staying in touch with him.
Excuse me, is my husband coming?
10 minutes away.
No, I know, but I really would prefer that my husband's with me.
Of course.
Am I in trouble? Like I'm so lost right now. I'm
sure you are. Like I said, I can't answer any questions right now. I'll just tell you that right now you're being detained for an investigation and we're bringing you to the police department. And once you get there, they're going to fill you in on everything.
The suspect may seem indignant as she's transported to the Downers Grove police station. But let's see if things have changed after nearly 7 hours of police questioning as she's transferred to the DuPage County Jail.
Mm.
I'm just going to put your seatbelt on, right? Unless you're able to reach it down there. Sure you don't want a tissue or something?
I'm feeling I'm gonna throw up.
You want a bag?
Yes, please.
All right. Shauna, can you grab like a bag out of there? Hey, can you get like a bag just in case she gets nauseous? Yeah. I don't know. Do we have any of those MSS bags like laying around the block? I figure something better than nothing.
You don't have a damn panic attack now. You didn't mind sitting up there helping yourself with somebody's child. Let's not, you know what I mean?
Oh my god.
She's crazy. Girl, it's over. It's over. It's over. You fucked up. You fucked up big time.
Kind of put it on the floor.
Your husband's not going to look at you the same. Everybody's going to be, your career is over.
Okay, thank you.
Leave people's children alone. 15 years old is not a man. It's a boy.
The suspect, 30-year-old Christina Formella, was charged with 2 counts of aggravated criminal sexual abuse and 1 count of criminal sexual assault against a minor. If you or anyone you know...
Okay, let's pivot real quick. I think they did put her on leave with pay, and just a second. She ought to really, I mean, she's in serious trouble. That's definitely for sure. Okay. Let me get this and then we'll pivot. I cannot imagine and how embarrassing this is going to be. So, but this is on her.
Teacher at Downers Grove South High School, who is also a soccer coach, is now facing sex abuse charges. that teacher, Christine. All right, so these are some really disturbing allegations. A teacher at Downers Grove South High School, who is also a soccer coach, is now facing sex abuse charges. That teacher, Christina Formella, is accused of assaulting a 15-year-old boy allegedly inside a classroom. NBC5's Natalie Martinez tonight has reaction from a school board meeting.
A troubling statement led off the packed public hearing tonight in Downers Grove regarding a special ed teacher and soccer coach, Christina Formella.
This morning, we learned that a DGS teacher was arrested and detained by law enforcement. The teacher was arraigned this morning and charged with aggravated criminal sexual abuse and assault of a current DGS student.
In fact, the meeting was mostly about district finances and gathered dozens of community members. Still, district members are concerned.
We are heartbroken for the victim and also for the hundreds of students, staff, and family who trusted this teacher.
District 99, in a statement to students and families, said in part, Formella has been teaching our special services department since the 2021 school year. She was a volunteer soccer coach starting in the fall of 2020 and has been on the coaching staff for girls and boys soccer since 2021. In an 8-page petition to deny pretrial release, DuPage County State's Attorney's Office points to explicit text messages from the then 15-year-old boy and then 28-year-old Formella. She allegedly had sex with the boy inside a classroom at Downers Grove South High School in December 2023 when she was his tutor. Formella was also his soccer coach when he was a freshman. The two allegedly started the inappropriate relationship with flirtatious texting.
We will also be contacting those families whose students have had direct contact with the teacher and coach.
The student's mother, after discovering his text thread, took her son into Downers Grove Police over the weekend. Formella was arrested Sunday after a traffic stop. She denies having sex with the student, accusing him of stalking and blackmailing her. Formella is on administrative leave with pay, and she's not allowed inside the school or in contact with anyone under 18 years old. In Downers Grove, Natalie Martinez, NBC5 News.
Okay, let me read you guys this real quick. Just a second. There's some people absolutely going bananas right now. Okay, so it's her mugshot. It says, so this is what was released from the state attorney's office. Okay. The DuPage County State Attorney Robert Berlin and Downers Grove Chief of Police Michael DeVaries announced today that Downers Grove woman has been accused of having an inappropriate sexual relationship. They have the whole entire text. They have some text thread from her phone. It's a mess. So I'm trying to get my hands on everything, and once I do, I'll bring it to you. I'm going crazy because somehow this has got to stop. It's disgusting. Okay. I'm telling you, you got to, and I know everybody's work schedules are different and everything doesn't permit, but I tell you, me personally, I show up at the school whenever the coaches, teachers, and that's not a foolproof thing, but I think sometimes people take advantage of the kids that they have a lot of access to. Like sometimes kids get rides home from teachers, which is not appropriate. I think our school district, they frown upon that. Like you're not to give a kid, like even in a state, and even in emergency, I think there's other resources you're supposed to use if a kid needs a ride. And just limiting your personal interaction as much as possible outside of school, what's appropriate for school, right? These kids are at risk because there's people out here taking advantage. Why this woman would put herself in a position, even if he was flirting with her, you need to understand that these young men and young women are young and they don't know what they're doing. And you as the adult in the room, even if you're in your 20s, needs to know better. You need to know better and do better, right? Okay. Woman has been accused of having an inappropriate sexual relationship with a student, Christina Formella, 30, date of birth 12/29/1994, of the 1300 block of Hughes Avenue, appeared in first appearance court this morning, charged with one count of aggravated criminal sexual abuse, class 1 felony, and 1 count of criminal sexual assault. If you guys want to see this page. Class 1 felony, and 1 count of aggravated criminal sexual abuse, class 2 felony. At her appearance, the court denied the state's motion to detain Formella pre-trial and released her with conditions including no entry into Downers Grove South High School and no contact with anyone under the age of 18. On March 15th, 2025, the victim, who was 15 years old at the time of the alleged assault, and his mother went to Downers Grove Police Department to report inappropriate sexual contact allegedly committed by the boys' soccer coach / tutor, later identified as Formella. Following an investigation by the Downers Grove Police Department and DuPage County Children's Advocacy Center, it is alleged that in December 2023, the victim and Formella were in a classroom for her tutoring session before school began, when Formella sexually assaulted the boy. On March 16, 2025, Downers Grove's detective conducted a traffic stop on Formella and took her into custody. The victim's mother discovered the alleged assault when looking through her son's text messages thread on his cell phone. The allegations against Miss Formella are extremely disturbing, Berlin said. It is alleged that she used her position of trust and authority as a tutor and a coach to sexually assault a minor student. This type of abuse and behavior alleged in this case will not be tolerated. I thank the Downers Grove Police Department for their efforts in this case and authorities at Downers Grove South High School for their cooperation in this matter. I also thank DuPage County Children's Center as well as Assistant State Attorney Jacqueline McAndrew for her work not only in this case, but for their continued effort protecting children. I want to thank, even if he framed her, what framing? The boy is not in an age of consent. So he could have framed you. He could have propositioned you. He could have tried to seduce you. You are the adult in the room, and there is no consent for a 15-year-old. 15, it doesn't matter what he says. He's not in a position to consent and engage in a relationship with a grown-ass woman. So that, okay. Let me see. I lost my spot. Okay. I want to thank our team of detectives for their dedication and through investigation of this deeply concerning case. The safety and well-being of the children remain our highest priority, and we take all necessary actions to ensure that anyone engaging in this type of conduct will be held accountable. I would also like to thank DuPage County State's Attorney Robert Berlin, his office, and the DuPage County Children's Center for their assistance in this case. Formella's next court appearance is scheduled for April 14th, which was what, last week? Like 9 days ago. In front of Judge Mia McPherson. Members of the public are reminded that this complaint contains only charges, is not proof of the defendant's guilt. The defendant is presumed innocent and is entitled to a fair trial in which the government's burden is to prove his or her guilt beyond a reasonable doubt. Okay, period. A mess, right? When I find some more information, I'm kind of hunting and looking, and I sent a FOIA request because the docket is online. The docket is here. Hold on. The docket is here. But the items on the docket, like you can click on it, but I can't get to it. So I'm not sure what I need to do to be able to access we like receipts. So this is part of the docket and everything. But I'm working on it. Okay. Anywho, a mess. Okay, guys, I'll be back in a little bit. I'll be back at 2. STEPHAN STERNS has a full hearing scheduled for 3 hours, and it's going to be a motion to suppress. Let me see if I can find the actual motion to suppress. Give me just a second to pull it up. And I feel like I pulled it up. Just a second. State defendant motion to suppress evidence obtained. I think this is the one from the So, okay, you heard earlier, right? So back to Stephan STERNS, right? They mentioned that his attorney filed 3 motions to suppress, right? So, state responded to, okay, let me see. So they filed a motion to suppress evidence obtained from unlawful seizure of a cell phone, evidence to suppress unlawful search of the cell phone, and also a motion to suppress evidence obtained from Google search warrant. All right, I'm going to pull all of that. Okay, I see them right here. 1, 2, and 3. Girl, these are a lot. We might have to, let me pull all these documents. I will post them so you can read the motions to suppress, and then you can read the state's responses. And I'm quite sure it's going to be interesting because Mr. J from, the Sarah Boone trial he's in the house. Okay. So you already know the state's response. Now we saw counsel. Ooh. Let me see. Are we not gonna be able to see this one? I need to refresh my login because it's not coming up right away. Okay, hold on. I need to refresh. Okay, let me see. It wasn't showing restricted, but for some reason I couldn't pull it up right away. But I've been logged in on this page for a while, so it might make me log back in again. Okay. Okay. So that's 6 documents. Let me get them and let me pull them, save them all to my computer. And all right, let's see if I can get them. 1, 2, 3. Okay. I'll see you guys in a little bit, and then so we won't have a chance to read them before, but I'm sure they're going to talk about them. But anybody who wants to read them, I'll pull them for you. But these are all easily accessible. You guys know this. You guys all have access to the dockets, and you guys can pull some of this information yourselves. But I can pull it so you don't have to. I'm in here right now. Let me see. Girl, it's small, isn't it? These are them right here. Remember, she said they filed them in February. Motion to suppress evidence obtained, unlawful seizure of a cell phone, search of the cell phone, and the Google search warrant. And then the state responded, boom. Okay. So they filed them on 2/6/25, and the state responded 4/8/25. Okay. Anyway, let me get these saved and try and get them posted. But worst case scenario, I will be live in a little bit. This is going to roll you into the live. So hit the notify me just to make sure you get your notifications, because you know how YouTube is. You may or may not get your notifications. So I will see you at 2:00. It's already posted, and just go ahead and roll on in there. Hit the notify me button. Even if you've already got notifications set, do it again. That way you can be notified as soon as we start the live. Okay. All right, guys, I'll see you in a little bit. Okay. Talk to you later. Hope you enjoyed this lunch. Thanks for everybody who came through. If you're on the replay, what's up? Hit the thumbs up for me, and I will see you down in the comments. Okay, I will see you down in the comments. Bye.